Hi guys, good afternoon to one and all. Today we will be starting with the intellectual property laws as per the new syllabus of CS Executive, which is there in CB IPR. Now IPR itself comes for around 40 marks in your particular portion in new syllabus. I will be covering all of it in the series of lectures that is going to come every day now. So before I start, I want you to put in the chat box if I'm audible and visible to you. So we can quickly start with the first chapter of your intellectual property law, which is the basic introduction, lesson 15. So I need you all to put in the chat box if I'm audible and visible or not. Okay, good afternoon, Naseem, good afternoon, my voice, Sona, Purnakshni, great. Okay, so I just need a confirmation from your end in the chat box whether I'm audible and visible, and I will quickly start with the lecture. Audible, yes or no? Okay, great. So let's begin with the particular topic and the lecture. Okay, you can be participative, you can mention in the chat box also whatever you want to say. Okay, if I'm asking any questions, etc. Great. Can old syllabus students see this video? Yes. So basically in the old syllabus also there is one chapter of IPR, which after you do this particular chapter today, you can go up, open your old module and finish it off from there as well. Okay, great. So let's begin. Hi, so we'll be starting with the first chapter of your intellectual property law that in the new syllabus, that is your lesson number 15. Now let's understand what is intellectual property. Now intellectual property in simple words could be called as creations of the mind, can be called as creation of mind. That's your intellectual property. For example, if you've written a book or you've written a movie script or even creations of mind could be written songs, it could be an invention that you have done, etc. So all of that is called as intellectual property. Intellectual property has been divided in two categories. One is called as your industrial property and the other is called as non-industrial property. So you have industrial property as well as non-industrial property. Now industrial property is what we commonly understand is trademark, patents, designs, geographical indication. So trademark, patents, designs and geographical indications. Non-industrial property is your copyrights. Now copyrights is something where we see with respect to literary work, any kind of writings, artistic work, your paintings, music compositions come under copyright. Even softwares come into copyrights. So industrial property, when they ask you because they believe that these are mostly product based, these go into manufacturing processes, trademarks are manufactured, patents are your inventions. If a particular product is invented, okay, let's say electric car, the entire working of how the electric car operates is a patent. Designs is the aesthetic design of a particular product. For example, if you see a building, architect could get his designs protected under the Designs Act. Also, if you see certain fashion designers, when they make a design, it's immediately copied by others. So they can go ahead and protect themselves in the Designs Act, and if they found that any person is copying their designs, they have a right to sue them. Geographical indications are basically products coming from a certain territory which promise a certain kind of quality, purity, standard. They have been given an additional mark. For example, your Kashmiri apples. We know that if an apple is coming from Kashmir, it has a certain kind of value, additional value. So this kind of a mark is put up there. Geographical indications, we'll also see where it is there, or you could have your the Kanchipuram saris are there, or Tirupati laddus, which all come in GI marks, which we will see when we do. Now I will explain the particular trademark, copyright, patents, designs with the help of an example of Apple. So Apple Computers is a company registered in the United States. They have multiple intellectual property rights over their products. So first, if we go to see with respect to the logo, this logo, they have gone ahead and registered it as a trademark. So a trademark is simply by seeing the logo, but it's a visual symbol. It is a graphical representation with which the users or the consumers can identify the company. So even if I don't give you the company name, I simply show you the logo, you will be able to identify it is related with which company. So Apple has registered the name. Apple has been registered as a trademark. Even the logo has been registered. Next, if we go to see patents. Now patents are related with a particular invention. Okay. For example, a water purifier. How is the water purified? If it is something involving intellectual advancement, technological advancement, you can go ahead and register. So patents are related to inventions. For example, a electric engine, if you have done inverter ACs, any kind of particular invention that you have done on a product will be patented. Now Apple holds among the top 5 maximum number of patents are held by Apple. The first is around Samsung, then IBM, and then also there is Apple, who have the maximum number of inventions in their name. So they get their patent registered so that nobody else can make a product similar to them. So Apple has even have patents in their name. Now when we see of designs, now Apple has also got 2,700 registered designs in their name. Now when we see designs means what? Now design is the appealing to the eye. With the eye can figure out that this placement looks very nice. If you see a graphic designer, if he's made a beautiful graphic, it is pleasing to the eye, it is attractive to the eye, he can go ahead and register it. So Apple has registered 2,700 designs. For example, the way they have made the phone with one button in the middle, they have got it registered. Next, the placement of the apps, how it will be done, all of this has been registered. So the design of the phone has been registered. The design of the Mac has been registered. Design of the iPad has been registered. Design of the particular music iPods have been registered. So not only that, the placement within is also registered. So if you go to see, there are something like UI and UX designers, the user interface designers who design the websites, who design the products. That design also can be registered. Apple has done that. Then with respect to copyright, now in copyright, if you go to the Apple website, you will see that their website has been copyrighted. The contents within has been copyrighted. So copyrights is mostly with respect to artistic or literary work, written work, etc. So Apple has gone and registered copyrights as well. So as I told you, just taking a name of a company, just taking a reference example of a company, we saw that a company can register its trademarks, its copyrights, its patents, its particular design. All of this has been done, and all multinational companies dealing in products, services get themselves registered under multiple IPR laws. We will be seeing each law in detail and we have chapters for trademark, we have a separate chapter for copyright, a separate chapter for patents, a separate chapter for designs. How to register, where to go and register, what is the cost of registrations, what are the terms and conditions, what are the filing fees, for how long will this be in your name, all of that is being given. Even the right when if someone else is using your particular intellectual property right, where can you go to prevent the misuse of it, etc., is all given under the Act. Currently, we will be seeing a chapter overview, that is your intellectual property. Whenever I say intellectual property, it is a creation of the mind. It's a property which has been created with the help of your intellectual efforts, your mind. So in simple words, if we go to see the basic introduction of intellectual property, it means that it's a property which relates to creation of the mind. The book that I have written is an intellectual property. If someone copies the book and puts it in their name, the author gets a right to compensation. He can file a case of infringement. That is a violation of the author's rights. All of this we will see. Human intellect is called as intellectual property. It prevents others from using their inventions. Now, in intellectual property, you get rights. Now let's understand what is intellectual property and what is intellectual property rights. So first, the difference between intellectual property and intellectual property rights. Okay. Now when I say of intellectual property, it simply means what all invention you have done is your property. But on that property, what rights are you getting is given under the laws. That is the rights given to you. So rights can be divided in two categories. One is your positive rights and the other one is your negative rights. So positive rights are all those rights which you can do, okay, which the inventor can do. For example, if the owner of the intellectual property has a right to use the product, to use the invention, to destroy the invention, to give it out on rent. Now here we call it as assignment. Assignment means giving it to another person for use, for getting some money. So they get royalty and they say, okay, fine, you can make a movie on my book, give me so much royalty. So this is the rights that you have which you can do. Okay, so you can use, you can destroy, you can something, rent it out as your property. You can rent. Here it is called as assignment. Okay, assignment means transfer of a right to someone else. Negative rights is which you say that you cannot do. It is for others. You have a right to prevent others from doing something. So you can disallow others from doing, that is using your thing, or if they are using, you can file for infringement, that is misuse of your unauthorized use of your product. You can ask for compensation. When you assign, you get something called as royalty. Okay, so this is the rights that you have over your property. Now this intellectual property rights, it is said that it is the backbone of the economy. Now imagine a very interesting question: how can something become the backbone of the economy, and how does it generate revenue and boost creativity? Can you tell me how does intellectual property rights or intellectual property laws do two things? How do they boost the economy? Can you tell me how do they contribute in, how do they boost economy, and how do they boost creativity? Okay, how does intellectual property rights do this? So the answer is very simple. First is, if I am the author and I know that the laws protect my rights, so I will be encouraged, I would be motivated, I would be finding it financially sensible to apply my mind to create new innovative products. So it will boost creativity. Yes, it will boost creativity because I know my laws are protected. I know I'm going to get I'm going to get protected, I am going to get revenue, I can assign it, I'm going to get royalty. Next, how does it boost the economy? Now, as the creative forces, for example, even YouTube creators today, they make their content. Now that is particular, they get a lot of revenue. We have seen so much in the recent times, the amount of creative art that is coming up and how much the content creators are earning. It automatically increases their income. So since their income increases, obviously the economy and the GDP also increases, which also increases the tax collections. So this has now become the backbone of any economy, as compared to something extremely opposite, that if the creators' rights are not protected, it will kill the creativity and you will not see any developments and innovations coming from that country anymore. So, intellectual property right, which has been created by an exercise of intellectual faculty. Faculty means talent, efforts. It is a result of intellectual activity. So it takes a lot of trial and errors that goes on to first come out with a successful product. Intellectual property refers to creation of the mind, such as inventions, designs, artistic works, symbols, etc. Intellectual property rights allow the creators to have the benefits from their work so they can commercially exploit it. What does this mean? It means that if I have I have invented a product, I can assign it to someone and I can get commercially benefits, I can get royalty on a constant basis. These rights are statutory rights. So the rights that creator gets is actually legal rights. He can get the remedy in court if it is affected. Okay, intellectual property laws reward the creativity and human endeavor, and it fuels the progress of mankind. Next, if you go to see the areas of intellectual property that is covered is two. Okay, there are two areas of intellectual property, which I told you, industrial and non-industrial. In industrial, you have trademarks, copyrights, GI, service marks, etc. And in non-industrial, you have something called as copyrights. Copyrights are nothing but rights of literary work, artistic work, sound recording, broadcasting. All of this we will be seeing in a detailed chapter. So copyrights and trademarks are clear. Let's understand what is a service mark. Okay, now we've understood trademarks. Trademarks could be applied on goods as well as on service. See, your trademark is nothing but a mark, or a simple words, it is a logo. Logo when applied on goods, for example, your Mercedes Benz, they have a particular logo. The BMW, the Merc, okay, they have these kind of logos. Tata group company, they have a logo. So that is a trademark. Now what are service marks? Service marks is basically when the company is dealing in services and has a mark. For example, if I am dealing in services, how will I have a trademark? Services, how will I have a trademark? Obviously, you go to see your telecom companies. Jio has a mark. Your Vodafone has a mark. Any kind of service providers, even coaching classes, we also have our logo registered. So even services can get their mark registered, which can more correctly be called as service marks. So service marks are also trademarks, but this is applied on services. Next, if we go to see, again they are saying that intellectual property is a vital component of economic growth and a tool for corporate competitiveness in a highly competitive global market. Now, if you go to see, your market is extremely competitive. If you want to be at the top of your game, or you want to be extremely successful, you will have to be intellectual. You have to exercise some kind of intellectual exercise, creation, some kind of USP has to be developed in your end, and you need to nurture it till you reach the top. Okay, so it's a highly competitive market. In the highly competitive market, you need to find your sweet spot and dominate it. Okay, so intellectual property rights serve as a catalyst for development of innovations and invention. So catalyst is basically, if we have these IPRs protection, and I know that if I make I launch a book, it won't be copied. If I create a content, it won't be copied. Okay, so if I know that laws are protecting me, I will be motivated. It will be a catalyst. Just by being these laws just by the laws being there protecting you, it will lead to creativity in the market. In order for inventors or developers of that property to profit commercially from creative efforts, IPR grant them specific exclusive rights. Now again, we saw that the creators gets exclusive rights. Exclusive means nobody else can use. Only they get rights over their intellectual property. There are various forms of intellectual property: trademark, copyrights, patents we have seen. Now one very important line is, if there is a human intellect or there is some creation of the mind, it has to be original. So many times when we have songs which are remixes, or movies which are remixes, may not get a copyright protection, because the original owner will have the copyright owner rights. So if I have let's say if there is a book which has been copied, so you won't get protection in that. A song or a movie script which has been copied will not get protection. So very important, in order to get protection under laws, it has to be new, it has to be novel, and it has to be useful. Legal privileges are granted to the inventors to safeguard the invention. So there are a lot of legal protections which we will see when we do the laws. Okay, they are all called as intellectual property rights. Now just as on your house you have a lot of property, so this is a tangible property. You would have a right to sell, you have a right to destroy, you have a right to transfer, you have a right to rent. Similarly, same rights are there on intangible property also. You have a right to use, you have a right to sell, you have a right to assign, you have a right to destroy. Okay, so for a specific amount of time, these legal rights are granted to the inventor so that they could exploit their rights and get commercial benefits. Now, very important, since it gives the inventor an exclusive right to exploit their invention for a specific period of time. So we will see, that it's not unlimited time of protection that you get. Different kinds of technology, different kinds of intellectual property have been given different duration of protection. For example, like a book, government can tell you that it is protected for the author's life plus 60 years. After 60 years, that book can be used. So we will see the length of trademarks are protected for 10 years, then you have to do renewal. Patents are protected for 20 years only. Broadcasters' rights are protected for 25 years. So we will have to see the different kind of intellectual property for how much duration protection is given. After the duration is over, some intellectual properties can be renewed and you can get protection continuously if you keep the renewal fees, and some kind of property like your patents, that is inventions, will be protected only for 20 years, after which it will go into public domain. That is, protection is given only for 20 years to earn. After that, it will go into the public domain. By enabling healthy competition, it contributes to the economic development of the nation. Now, coming to knowledge and ignorance, if a country is ignorant about these laws, okay, lack of understanding of IPR leads to the demise of invention, means the invention will stop, creativity will completely stop. A high danger of infringement, financial loss, and end of nationals intellectual era. So it is two things. One is, if you give the rights, it will lead to creativity. But if you don't give any protection, okay, then automatically it will lead to killing of creativity, demise of invention, and financial loss to the creators. There will be huge amount of copies infringement that will happen. That is unauthorized use of the product. So therefore IPR laws are necessary. Therefore it is critical for countries to have IPR knowledge, okay, proper IPR protection, and all the stakeholders should know. That is your government laws, your policy makers, your technology, your academicians. Everybody should encourage and promote using the best IPR practices. Now we understood trademark, copyright, patents. So for each of the intellectual property, there are acts made. So for patents, you have Patents Act 1970. For trademark, you have Trademark Act 1999. For copyrights, you have Copyrights Act 1957. You have Designs Act 2000, and you have your GI Act of 1999. Each of which we will be doing in detail. Now, then comes nature of intellectual property. Now when we say nature, means what we are comparing. We are trying to understand what is intellectual property, how is it different from tangible property, what are some of the special features of intellectual property. So let's see. First, intangible property versus tangible property. Now tangible property are properties which can be felt, touched, okay, whereas intangible property are creations or innovations which are there in the product. So the main is, in intellectual property, the intangibility is the primary characteristic which sets it apart from other parts of the property. Let me give you an example. This particular calculator is a tangible property, right? But we are in your intellectual property, we are not talking of this physical element. We are talking about the creation of mind, the intellectual effort that was put to make these calculations done, the placement of objects, all of that, which is a mental game, which is a creation of the, which is a development of the mind. Okay, although there are many differences, this is what they are saying, that the main intangibility part is there. Even if the book that I have written, the intellectual property is not in the pages, is not in the tangible element. It is in the words which are framed, the layout which it is made, the sequence of thoughts, the words that has been used. It's the mental process which is protected. Although there are many significant differences between various type of IPs, different kinds of IPs are different kind of characteristics, different kind of protection. All share is the establishment of intangible aspect, like idea, inventions, science, as opposed to their tangible object, tangible counterparts. So tangible is something thinking, which you can touch, feel. That's not what we are talking about. That is what is difference between tangible and intangible. Then the next thing is a right to sue. Very, very important in intangible property also. If it has been infringed, that is unauthorized use of your intellectual property, you have a right to sue. So this creation, you can be inherited. So let's say if I have made a product, my child can inherit the rights. I can it can be purchased by someone, it can be gift to someone, it can be licensed to someone. I can even pledge, I can keep the asset as security and take a loan also. So all of that is permitted. And if anyone tries to misuse or make counterfeit goods, are good examples here. For example, we know the company called as Adidas. Okay, and now there are lot of fake goods that come up using the same thing. So they have a right to file the case because they resemble the original manufacturer. They are trying to sell the goods to the customers thinking that they are the original manufacturer. So the case can be filed. So your legal rights and legal actions can be taken. Okay, it can be taken by those who have a legal standing. So anyone who has a legal right over the intellectual property can file the case. They also have a right to sue and get compensated. So sometimes Apple has also filed a case. It had filed a case on Samsung tabs, where they said that Samsung tabs have copied our design. And there was a case where Apple won the case. Apple said that an injunction should be given. An injunction is a temporary stop till the final decision is given from selling. So that injunction was also in Apple's favor. Till the pendency of the case, Samsung could not sell the tabs. One. They also said that all the tabs which are there should be given in our custody because they are our product. And second is any kind of the loss that they have caused, we should also get it remunerated. So if you just Google up, you will come to know Samsung lost the case to Apple. Rights and duties. Now obviously you get rights, as we saw, right to use, etc., transfer, and duties also you get. Like for example, over the intellectual property, you get some of the duties that you have to pay the renewal fees. You have to see that you have not copied it, you have not infringed someone else's rights, and then you can fully exploit your work. So others' rights should be protected. For example, if I am dealing in a product which I know is very similar, or I have got motivated from another product, it's exactly same, and I try to copyright this. So again, it's my duty not to do such things. Coexistence of different rights. Now coexistence of different rights means what? That various kind of IPRs may coexist on the same product. For example, if I go to see a Pepsi can, okay, for example, this is a Pepsi bottle, and you compare it with a thumbs up bottle, okay, the thumbs up bottle. So this is your thumbs up, okay. So Pepsi versus thumbs up. In this, if you go to see, in one product there can be multiple copyrights, multiple intellectual property rights that can arise. For example, Designs Act, you can get yourself the shape of the bottle can be copyrighted, can be applied in Designs Act. So Designs Act can be applied. So if you go to see the bottles also, when you see these soft drinks bottles, each bottle, just by the shape you can identify which bottle it is. So they get themselves under the Designs Act. Second, the logo can be put in trademark, right? Then the website on which it is there can be copyrighted, or the particular tagline can be copyrighted. You know, what is the tagline for Pepsi? Can you put in the put in the chat box? Tagline for Pepsi or tagline for thumbs up. As you see in Red Bull, you have Red Bull gives you wings. So that tagline can be copyrighted. So multiple thing can be there. Okay. Now the next one is exhaustion rights. Now let's see what is exhaustion rights. Now exhaust means to get over, okay, to get over or finished. So when a particular owner of a product, a person who has rights over the product, intellectual property rights, he sells the product. So some of his rights get exhausted, gets over, there is diminished. For example, if I have sold a Ferrari car, okay, I am Enzo Ferrari, I am the owner of Ferrari. I have the car designed, I have the car in my name, logo, everything is in my name. I sell the car. Don't you think some of the rights of mine will be diminished, exhausted? For example, he is now the owner, he will have a further right to sell it, he has a further right to change the color, whatever he wants he can do on the product. Okay, so there are some rights which will be terminated, but if he tries to say that it is his car, that won't be allowed. Okay, so some rights, when they get over, it is called as exhaustion of rights. Doctrine of exhaustion, it is important, it can come in the exam. Okay, it applies to intellectual property rights. Exhaustion of fundamentally means after the first sale is made by the right holder. For example, I have the rights over the property, I sell it. The person rights expires and he is no longer permitted to halt the movement of the goods moving forward. So this is not that he has lost all the rights. Some of the rights of movement has been restricted. All the property should be with me, but if I sell it, then that guy will do further what he wants to do with the property, including for the sale. As a result, one IP rights holder has sold a physical goods. As a result, once a IP right holder has sold a physical good that bears the IPR, it cannot stop subsequent sales of that good. The first consent mark that ends of the right. So the first consent that I give, okay fine, you can take the product, give me so much money, it ends some of my rights of movement basically is covered. This theory is founded on the idea of free movement of products, which is the legitimate by the owner's permission or right. It is prohibited to use exclusive selling privilege in connection of the same item twice. So that means if for the same item I cannot have two rights of sale. For example, I am also controlling the resale, so that is not covered. That rights are not given. So once I sell, then it can be freely moved by the new owner. Then comes dynamism. Dynamism means a growing phase. So intellectual property laws is undergoing continuous improvement. The realm of IP is expanding quickly as technology in all spheres of human activity. New things are being added to the intellectual property laws scope. I'll give you a very good example. For example, there are images, okay? Images or paintings or songs. Tell me one thing, this images, paintings or songs can be copyrighted by the owner, yes or no? Can be copyrighted by the owner, yes or no? So the answer is yes, it can be copyrighted. But imagine I have a AI website with which I have generated these images, paintings and songs. AI has generated these images, paintings and songs. Can this be copyrighted? Yes or no? So this is a dynamic question. Dynamic means it is a growing continuous question that is coming. In Indian laws, they have yet not put a provision for this, but in the US, it has been identified that this cannot be copyrighted. AI generated images and songs cannot be copyrighted. Now there was one singer, okay? Now AI, one person, what did he do? He told the AI to generate or to create a new song, as per XYZ artist. Then what happened, that the question is, does the artist, XYZ artist, has the rights over the new song, or the person who is telling the AI commandments is going to be there? So this is still in question which is there. However, it appears that the real owner should have a right to protect such kind of the artist should have rights in these kind of spheres also. So that's what they are saying, dynamism, that it is expanding with time. Okay, and new and more scientific advancements are coming in data privacy, etc. The value of intellectual property laws and its portability has long been recognized and is being represented in all the spheres of government, administrative and other judicial levels. So this dynamism is something about continual improvement. That is what you can write. Then comes need for intellectual property. Now very important, why is intellectual property important and why are these laws important? We just did. First is, I can say that it is to boost creativity. Second, it will generate revenue for the economy. Third, it will compensate the creator's time, efforts, resources that he had put to build this particular invention. So it will compensate. Okay, and these laws will bring in clarity and less disputes. So disputes will be reduced. Otherwise, every time there will be disputes of copying, allegations, etc. If the laws are strong, and we know it will discourage persons from misusing someone else's intellectual property. Every invention involves labor, time, resources. The length of each of the products vary substantially. A certain amount of actual money is necessary for creative endeavors. Any creative professional making all these investment is making a significant one. It is important to acknowledge the creator's intellectual works. Then we have certain worldwide conventions. That was GATT, that was WIPO, and there was TRIPS. All these have said that we have to safeguard and uphold the creator's rights. In 1967, the WIPO was founded as a UN body. Since then, the phase has gained significant traction in the US, a comprehensive international system for defining, safeguarding, upholding the creator's rights. It consists of various treaties. Okay, and India is also a party to it. We will see what does WIPO and GATT talk about. Now, coming to scope of intellectual property. When I say scope means what? Scope means what all is covered. So I told you, very simple. You will write about industrial, non-industrial. You will write about copyrights. You will write about patents, trademarks, biodiversity. Everything is covered under this. GI marks, etc. and their particular timeline for which everything is given here. Scientific work, technological work, almost everything is covered in the scope. So scope is generally covered under 5 acts: trademark, copyrights, patents, designs, and geographical indications. We have chapters on these. Now we had GATS, TRIPS, and WIPO. Okay, now the very first question about your intellectual property came in from the GATS. GATS is the first ever collection of legal binding regulations of trade in services. The outcome was in Uruguay round. Okay, so this all the GATS and these, we'll do it tomorrow. Okay, so from here onwards we'll complete it tomorrow. Concept of intellectual industrial property, we've done this. Trademark, copyrights, and then in the end we have something called as national IPR policy. So that is it for today. Okay, and then the chapter gets done. So we will be completing this particular chapter tomorrow. This is from the new syllabus point of view. Okay, and then we will start with the next chapters in sequence, that is your patents, trademark, copyright. Clear? So that is it for today. Tomorrow I will see you all again at 11:30. We will put the details in the WhatsApp and the Telegram groups. You all need to join it. It's there. It's pinned in the chat box. It's given in the Telegram groups, and also inform your friends, especially those who are giving in the new syllabus. Now, question was asked whether we will be taking marathon revision lectures for old and new. So answer is yes. We will be taking for old and new as well. For all the other subjects also we will be taking slowly. We'll first complete this, then we'll go into the other subjects also, and then closer to exams we will have a marathon which will really cover everything. Okay, so right now I'm covering two. One is company law parts and the other one is your IPR part of the economic commercial laws. Clear? So that is it for today. I'll put up the schedule soon of how we are completing. Okay, so right now you all can study this much, finish your chapter till here. The next part I'll complete it tomorrow. So that is it, guys, and do watch the previous lectures also before it is made private. Okay, so that's it, guys. Thank you so much, and don't